Hello and welcome to the Herrington Carmichael Employment Law Update for July 2017. I'm Alistair McArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got 4 key subjects to talk to you about this month. It's 4 quite tricky cases, so please bear with me as I go through these. Let's start with the case of Ali and Capita Customer Care Management. This case related to whether an employee who was male was entitled to the same rights as a woman when on maternity leave in relation to pay. Mr. Ali took shared parental leave and argued that he should get the same level as pay as a woman on maternity leave. Effectively, shared parental pay should match maternity leave pay. The Employment Tribunal found that there was a case of direct discrimination on the grounds of sex, and therefore Mr. Ali was able to recover the same element of pay. This doesn't sit comfortably with me, I have to say. It's a case which is open to appeal, and quite probably there is an issue there with comparators as whether the correct comparator was used, because in theory a woman could take shared parental leave as well. Moving onwards, let's deal with the case of NPT Group and Peel. This case related to whether an employee was under a duty to inform their employer about the intention to compete. There was some questioning of the employee here where there was allegedly misleading information provided, and the employer argued there had been a breach of the duty of good faith. The court disagreed and said there was no obligation on an employee to disclose the intention to go away and compete. Again, this case doesn't sit comfortably with me. However, what we find is actually there could be a very different position here if an employee was a very senior individual and under a fiduciary duty rather than a fidelity duty of good faith, or whether there were strict contractual provisions in place. If you have employees who you are fearful that they will go away and compete, please make sure you look at your contracts and you get those correctly drafted in relation to the obligations upon employees. Moving on, the case of Sash Window and King. This is another case which adds to the long-running saga in relation to the payment for annual leave upon termination. And in this case we have an Advocate General's opinion which effectively gives us a little bit of an extra blurring of the lines. In this case, what was held, or the opinion that was given, was that if an employer does not provide an adequate facility or ability for an employee to take annual leave, then there is the potential that effectively the annual leave should be carried over continually and potentially paid upon the end of termination. Now this case is only an Advocate General's opinion. We have to wait and see what the European Court of Justice has to say about it. And I expect there's going to be a difference in view when this actually is given the full European Court of Justice opinion. However, we'll have to wait and see. Finally today, the case of Green versus SIG Trading Limited. This case related to the ability for an employee who was employed across 2 jurisdictions, Great Britain and Saudi Arabia, to pursue employment rights within the UK. In this case, the employer tried to argue that there was not a sufficiently close connection to enable the claim to be pursued in the UK. But actually, in this case, the Employment Appeal Tribunal said that the contract of employment clearly provided that the decisions were to be governed by UK law, and the decisions on the employment was made in the UK, giving the ability for the employee to pursue their rights within the UK. Where does that leave us? That leaves us in a situation where if you have employees working cross-border in more than one jurisdiction, please look closely at their contracts. Please be very clear as to where their rights lie and which laws govern the jurisdictions. And be careful in terms of terminating employment for employees across border, and consider carefully whether you still have to comply with the UK rights. That's it from me this month. I wish you all a very good rest of the summer, and I'll be back in August. Thank you.